My name's Sid Mendelson. I'm the Director of the Division of Investment Management. On my immediate right is Stan Judd, Assistant Chief Counsel. On his right is Sid Simmet, the Chief Counsel. And on his immediate right is Larry Bardfeld, Special Counsel. All people obviously are from the division, and all except me are from the division's office of the Chief Counsel. This course will be given very informally, and I want to say at the outset that if you are not an expert on the Investment Company Act when you start, you won't be when this course is finished. But the aim of this course is a walk through the statute, giving the speakers experience and the information which he has gathered over the years. I think it's important to state that this is one of the few statutes that is almost entirely regulatory. The 33 Act and to a lesser extent the 34 Act are disclosure statutes. But this statute started out as a regulatory statute. And in 1940, after the investment trust study was completed, the Congress determined that a statute of regulating the investment company industry was appropriate. Now, you'll notice throughout the course that many of the sections of this act don't hold together as well as you might think they should. And this came about, generally speaking, because in 1940, the Depression was about over, and the securities industry was getting back on its feet. And as a result of this, they had more of a say as to what went in this statute. This statute is a large group of compromises. This was not evident in the 1933 Act or the 1934 Act, where the credibility of the industry in that period of time was not at its highest zenith. On the other hand, by 1940, the situation had changed considerably, and unfortunately, from the standpoint of the Investment Company Act framers, the Congress's mind was not entirely on securities regulation, but rather on the impending war in Europe and the involvement of the United States. So with that in mind, I'd like to discuss with you the purposes of this act. And 1B of this act is very important, probably more important than the introduction to any of the acts that we have under the as an administration in which the Commission administers. The policy and purposes of the act are these: that the Congress set forth the abuses. It said the national public interest and the interest of investors are adversely affected by certain conditions, which then were enumerated in Section 1B. And I'll just enumerate them, just go over them with you. Inadequate, inaccurate, or unclear disclosure with respect to the investment company and its securities, causing investors to purchase, sell, or vote securities without enough information. 2, self-dealing of insiders and special interests, and the company was run for the benefit of the insiders or controlling persons. 3, the issuance of securities with inequitable terms, failure to protect the privileges and preferences of outstanding security holders. Now, what's meant there is that you would have a preferred stock, and suddenly, without any warning at all, there would be another preferred stock issue called first preferred or preferred, and there was no protection for those security holders who had purchased the first preferred. The same with bonds. All of these securities had, the Congress found, had no protection. None whatsoever, depending upon the state of incorporation. So the investors never knew what they had as far as priorities were concerned. Inequitable distribution or methods of control, irresponsible management. Here you have the beginnings of what I would call Section 36, which we'll get into later on in the course, where the management, the investment advisor, those people running the company were totally irresponsible and had no concern with respect to their fiduciary obligations. This was quite rampant before 1940, as evidenced by the investment trust study. Unsound or misleading accounting methods, not subject to independent scrutiny. Well, today, we just take it for granted that all companies are audited, and that all companies operate with a generally accepted accounting methods. Unfortunately, before 1940, this was not true. Reorganizations, changes in the policy or transfers of control without consent of the security holders. Here again, a reorganization could come up at any time without the consent of the security holders, in which a person may find himself first holding what he would call a senior security or a common stock, only to find himself after the reorganization holding an inferior security, inferior to that which he had, without any consent on his part or on the part of the class of security holders which he was a part. Also, the policies of the company could be changed. In other words, it wasn't unusual for a company to say that they were going into conservative investments, only to find that they were going into very speculative investments, and the investors had no voice as to whether or not this change should occur. Accordingly, people obviously lost confidence in these companies, could not rely on these companies. As you'll see as the course continues, that the statute tries to correct some of this, particularly the change in policies. Excessive borrowing and excessive issuance of senior securities, which unduly increase the speculative character of the junior securities. In other words, it's again a repetition of what I said in a different form, that companies would go out without any restriction whatsoever, borrow as much money as they could. This obviously was one of the causes of the market debacle in 1929, where people were buying on margin and were selling short with very, very little security. Well, so the investment company industry was doing the same thing. It was borrowing as much as anyone would lend them. And prior to 1940, it was not difficult to borrow money. And consequently, you would have companies on with asset coverage very, very little with respect to their debt. And finally, inadequate assets and reserves, which is a variation of what I just said. Now, the most important part of what I have just said comes at the end of Section 1B. At the end of Section 1B, it says that it is hereby declared that the policy and purposes of this title, in accordance with which the provisions of this title shall be interpreted, are to mitigate, and so far as is feasible, to eliminate the conditions enumerated in this section which adversely affect the national public interest and the interest of investors. Now, what does that mean? Well, that means this. When you're interpreting the statute and you have a close question, you interpret it in a way that will eliminate the conditions set forth in Section 1B. Purportedly, when the courts look at this statute, they will keep in mind the purposes of the statute as enumerated in 1B and make their interpretations so as to eliminate, as much as is feasible, the conditions set forth in Section 1B. Throughout the statute, there are numerous phrases in certain sections, in the sections of the Act, which talk in terms of the Commission either promulgating rules or making findings which are as a result of the purposes of this act, of the Act. In other words, the Commission must find in order to give an exemption that the purposes of the Act are being served. And you look to the purpose and policy of the Act back to 1B. What was the statute made for? What was it trying to do? And so I suggest that you glance at 1B, you look at what it was done, what was supposed to be done, and you try to interpret the statute with that in mind. Now, if you have any questions, please don't hesitate to ask. We'll try to answer them here. And as I say, I'd like to conduct this as informally as possible. Are there any questions? If not, Stid, Stan, and Larry, sounds like a law firm, we'll talk about the definitions of the investment company, because without definitions and without knowing what we're talking about, the statute obviously is meaningless. And the one definition that is absolutely essential is how the statute defines investment companies.
Thank you, Sid. I'm going to talk about the statutory definition. As you know, an investment company is an arrangement by which a number of persons invest funds in a company that itself invests in securities, generally in securities of companies that are not themselves investment companies. Section 3A is the operative section in terms of definition of what an investment company is, and it has three alternative definitions. Since they're alternatives, it's important to note that you have to be outside of all three of the definitions to escape the Act. I'm going to discuss the two definitions two of the three definitions, the one in 3A1 of the Act and the one in 3A3 of the Act. Larry Bartfeld will later in the program consider the definition of investment company stated in Section 3A2, which is a bit unique. It's important to note at the outset that investment company status is not acquired or lost voluntarily. One's intent to become an investment company or not to become an investment company is wholly irrelevant. The result of that is that there will always be investment companies that are so-called inadvertent investment companies. The consequences of being an unregistered investment company that is being caught by one of the Act's definitions and perhaps not even knowing it are very severe, and they'll be explained later in the program by Stan Judd. I'd like to quickly read to you the two definitions, which we'll then go through sort of phrase by phrase. 3A1 says that an investment company is any issuer which is or holds itself out as being primarily engaged or proposes to engage primarily in the business of investing, reinvesting, or trading in securities. That sounds rather simple. We'll find out it's not always simple to apply that to a set of facts. In Section 3A3, you have the other alternative definition, which I'm going to be dealing with. That again says that you have to have an issuer and he has to be engaged or proposes to engage in the business of investing, reinvesting, owning, holding, two new words, or trading in securities, and owns or proposes to acquire investment securities having a value exceeding 40% of the value of the issuer's total assets, exclusive of government securities and cash items on an unconsolidated basis. Now, that's a lot to swallow, but let's go through it sort of step by step. First, Section 3A, 3A1 and 3A3. When I say 3A, I mean both of them. 3A defines an investment company as any issuer that fulfills the requirements of one of the three subsections, and and you therefore have to determine what an issuer is. An issuer, by definition, which appears elsewhere in the statute in Section 2, is a person who issues or proposes to issue a security. Note, an issuer is a person. Again, the statute defines the word person, and that can be a natural person or a company. And a company can be almost anything in the world for Investment Company Act purposes. By that I mean a company does not have to be a legal entity under state or federal law. Of course, it includes a corporation, a trust, an association, and a partnership, things that we would immediately think of as companies, but it's also defined in the Investment Company Act. The word company can include even an unincorporated organized group of persons. Normally, the identity of the issuer, that is, the company, is not in dispute, but in certain cases it can be a critical point, and we'll see examples of that later. Most investment companies, you should realize, are organized as corporations or trusts, are born to be investment companies, and their status under the Investment Company Act is never in dispute. It's the company not born to be an investment company who has to study the definitions and worry about them. Section 3A and Section 3A1 and 3A3 apply to a company that issues a security of its own and invests, reinvests, or trades in securities. And for most purposes, it makes no difference, I want to point out, that the securities that the investment company invests in are or are not subject to any of the other federal securities laws. For instance, even though it invests in securities which are not required to be registered under the 1933 Act when they're publicly offered, that exemption from registration under the 1933 Act does not impact the fact that a company investing in those securities would be an investment company under the 1940 Act.
Sid, would you consider municipal bonds as a good example of that?
Yes, a municipal bond fund certainly is a good example of that, or even a U.S. government bond fund. Neither one of those types of securities is registered for various reasons, exceptions and so on, under the securities laws, yet a fund investing in those securities is an investment company under the 1940 Act. The point of having a fund of such securities, I might point out, covered by the 1940 Act is this. One could say, well, government securities are very safe securities, and because of that reason, and perhaps for other policy reasons, their registration under the 1933 Act, when offered publicly, has not been made necessary. However, when you have a fund of those securities, it's easy to see that the fund can be as easily embezzled as if it contained any other kind of security, so that all the protections that the 40 Act was designed to accomplish would be as important no matter what the investment medium is. Now, you need, to go through the definition a bit more, you need an issuer who invests in securities. If the investment is in something that's not deemed to be a security, then you don't have an investment company. For instance, if you have a fund company, an issuer invested in commodities futures with, let me just say, assuming that the commodities futures are not considered to be securities, but invested in those commodity futures that are not considered to be securities, then you wouldn't have an investment company. On the other hand, you may have a company, an issuer, a fund, invested in something that appears to be real property, like orange groves, but has the orange groves are wrapped in a package of other features that cause it to be deemed a type of security which we know as an investment contract, a defined term in the definition of security. Then all of a sudden what appears to be real estate is no longer just real estate, it's a security, and therefore a company investing in such interests would be conceivably an investment company. Now, there's even a subtle point that I want to make here. Sometimes when securities are acquired by a company, does that always mean that the company is investing in them? It would certainly seem so, but that's not necessarily so. For instance, there was an instance where securities were held by a company, but they were purchased and held pursuant to the requirements of law that required that to be done by them because they wished to conduct the business of a bus line. Therefore, in that case, those securities would not be considered to be an investment in securities. We've also had a case recently where it appeared that an entity was holding an insurance policy. It was the holder, not the owner. It had no financial interest in the contract, and in those circumstances, and in some other circumstances that surrounded the particular fact pattern, one could easily conclude that the entity's interest in that policy was not a security, was not investing in that security. However, let me point out that even though a company has a purpose other than investment, it doesn't preclude the company from being an investment company if the purpose is achieved through investment activities, such as if you had investment activities carried on to teach students the art and science of securities. That would still be subject to the Act, although I believe in an actual case like that came before the staff, certain exemptions were granted. Now, both 3A1 and 3A3 require the company to be in the business of investing in securities. It is not enough that you invest in securities. You have to be in the business of investing in securities. But on the other hand, you don't have to show a continued activity of investment to prove the existence of a business. In fact, as you will note, in both sections 3A1 and 3A3, merely proposing to engage in the business is sufficient to trigger the application of the definition. It's difficult, let me say, to determine when a company in a transition period, now this is, I think, important, begins to engage in the business of investing. Let's take these examples. A company sells all of its assets for cash to go into a non-investment company business, or it sells its securities to the public to get cash to engage in a non-investment company business. But it can't very quickly apply the proceeds, either from the sale of its assets or the sale of its securities, in either case, in the non-investment company business in which it intends to engage, and so it sits there holding a lot of cash. And in the exercise of good business judgment, of course, it would invest that cash in short-term obligations so as not to be accused of corporate waste. And it would invest them, let's say, in treasury bills or certificates of deposit. Now, at that point, the company may have 100% of its assets in securities, because treasury bills are securities, even though they may be exempt securities, and certificates of deposit, as we'll discuss later, are normally securities as well. We've taken no-action positions in this area based on the theory that where the investment is temporary and is for the purpose of preserving assets pending entry into a non-investment company business, that's not being in the business of investing. Now, temporary, we've said, in our view, is a period not to exceed 1 year. Though we've taken no action in particular cases for longer periods, consider the unusual case where a company said we're temporarily invested. We are either going to, we've sold our assets. It was an insurance company. We're going to liquidate. Or we may go into some other business, but it won't be an investment company business. In the meantime, we have all of our assets invested in treasury bills. But we have to continue, a year has passed, we have to continue that posture. Question why? Well, our prior business was the business of insurance, and we sold the business, but the insurance commissioner tells us that there are many potential contingent liabilities that we may have to meet, and that in the meanwhile, we should not dispose of our assets. We should hold them in satisfaction of the possible contingencies and until they're resolved. In that case, we've taken no action for a longer period. Now, while we may take no action, an unhappy shareholder can sue at any time from day one. Let's leave that point for a minute and look at the proposed to engage in the business portions of the definitions which I mentioned before. Proposed to now, that can catch somebody in the definition of investment company at a very early point in time. For instance, I think it was the Townsend case. I may not be doing it completely factually accurate, but it goes something like this. I'll make up a hypothetical. You have a company, the board of directors decides it's doing something else, that it's going to become an investment company, and in furtherance of that decision, but before it gets any formal approvals or takes any steps, it hires a president who is familiar with the investment business and would be a good man to lead the company in its status of investment company when it achieves it in its mind. It gives that president certain warrants, which, if the company were required to be a registered investment company or were a registered investment company, would be prohibited. You can't give warrants. You can't sell warrants, issue warrants. It then later takes steps to get shareholder approval and eventually actually makes the investments. But it could very well be held that the company, and I think it was held in that case, the company became an investment company at a very early point in time when the directors proposed doing so. Therefore, the issuance of the warrants was void.
Well, then, Sid, you would take it that it's not necessarily the stated intent of the company that is material, but how the company acts in relation to its assets. For example, if a company would buy long-term equity investments or something that would obviously indicate to shareholders, if they were looking, that the company is not waiting for an opportunity, but has seized the opportunity of investment, so that being in the business of investing is a factual thing rather than a stated purpose of the company.
That's absolutely true, Sid, and we would not, for instance, sit still If somebody told us that they have all this cash and they're going to eventually go into a non-investment company business, but in the meantime they're going to buy some GM and AT&T and so on, that might make it much more difficult for us to accept the fact that they're for some temporary period not in the business of investing in securities. We would expect that the kind of investment, although again it's a factual question in each case, but the kind of investment that would indicate the kind of posture that we would be expecting is one evidenced by an investment in things like T-bills or CDs, which best suit the purposes that they say the investment is for. Now let's take a look particularly at investment companies as they're defined in Section 3A1, not Section 3A3, but Section 3A1. Remember, they're alternatives. 3A1 is the subjective test of the two. 3A3 is the objective test. If you look at 3A1, it's sort of conclusory. It says you have to be primarily engaged in the business of investing, reinvesting, or trading in securities. Now, primarily, unfortunately, is not a defined term. And so it's a subjective term. It's a question of fact as to what it means in each case. We look at the nature of the assets and the income. They're probably the most important factors. You look at the company's assets and income, but you can also look at the history of the company. You can look at the activities of its officers and directors. You can consider what public pronouncements it's made, which might indicate that it's led people to believe that it's an investment company. All of these facts would be looked at to determine if one could say that a company is primarily engaged in the business of investing. Now, obviously, if the bulk of a company's assets and its income derive from securities investment, it has an active portfolio. It neither controls nor is involved in the management of any portfolio company. Then the company is primarily engaged in all likelihood in the business of investing, reinvesting, and trading in securities. Section 3A3 contains the alternative objective test of what an investment company is. 3A3 defines an investment company, you should note, according to its assets and not its business operations, the latter being the focus of Section 3A1. Section 3A3 picks up companies with a substantial percentage of their assets committed to what are called investment securities. Now, that's a defined term right in the section. It appears right below 3A3. And in effect, it says companies with this percentage of assets in investment securities should be regulated as investment companies because of the significant amount of investment activity that indicates. Now, the test, as I say, again, is a company shall be regulated as an investment company. I'm not using the statutory language, and more than 40% of the value of their assets on an unconsolidated basis is in investment securities. This raises a presumption which is rebuttable, and Stan Judd will explain that when he analyzes Section 3B of the Act, which will occur immediately after this portion. It's rebuttable, as you shall see, by showing primary engagement despite the asset mix in a non-investment company business or businesses. The 40% arbitrary figure was selected, we're told, based on a study that was done by the Congress, which did not intend to capture in the definition holding companies and industrial companies operating through subsidiaries. They thought that the 40% figure would eliminate from the definition most of those companies, but in any event, if that wasn't the case, a procedure was provided for in Section 3B for arguing that any company caught up within the definition in 3A3 is nevertheless a company primarily engaged in something other than investment company business. The reason they thought that those companies, holding companies and industrial companies operating through subsidiaries, the reason they thought that they would not be caught up by the definition of investment company by using the 40% test and by defining investment securities as they did is because of the way they defined investment securities. In other words, what this part of the definition of an investment company requires you to do is to first of all figure out what the assets are of a company, and then that would be the denominator, and then the numerator would be the value of the so-called investment securities. And if it's more than 40%, the company is presumptively an investment company. Now, they thought
there is one proviso. Cash is not considered an asset here for this purposes. Isn't that right, Sid?
That is correct. I'll go through the exceptions in just a second, but let's take first. Let's focus first on the numerator. That is, what are the investment securities? The investment securities are all securities, but there are three particular exceptions. One is exclude government securities. Perhaps they were considered as cash. Two, exclude securities of employees' securities companies. Now, that's a very exotic form of interest which generally does not play a big part in any interpretive question. You'll find out what employees' securities companies are later in the program. And last of all, investment securities does not include securities of majority-owned subsidiaries of the owner which are not themselves investment companies. In other words, the theory is this. If a company owns more than 50% or more of the voting securities of another company, that other company is assumed to be managed and controlled by the parent company, and that it's not an investment by the parent company solely in the sense of investment, a normal investment would be thought of. So in applying the 40% test, you start off with the computation of what is the value of your investment securities as the numerator, and then as to the denominator, you take total assets and you eliminate government securities and cash items. And let me just make this point as to the denominator. You have, when you're talking about assets or when you're talking about the numerator investment securities, you're always talking in terms of the value, the current value of those things. It doesn't make any difference what the cost was. It's even worse if you consider depreciated cost. Rather, you have to take current value, and there's a definition in the Act of what value is, and you just look at assets. So, for instance, if you had $100,000 of assets, but you then went out, and we assume you're doing this not to avoid the definition of investment company, but you went out and you acquired a $1 million piece of real property with the rest of it was a mortgage. Now, the balance sheet would show $1 million in assets. There's no adjustment for debt. And likewise, we run into many situations where we get, for instance, an annual report of some kind referred by the Division of Corporation Finance, and it says the company appears to be an investment company, and you look at it, and certainly they have more than 40% of their assets in investment securities. But then you look at the valuation of the assets, and they'll show mining properties, $3.20. It's generally a tip-off that you'd better go back and ask the company what the current value of those property is. Now, frequently they'll come back. Obviously, their properties like that don't have a readily ascertainable market value. You can't look in the newspaper to determine it. So, the Act provides that the Board of Directors, in good faith, can value those interests. but some of them, because they're valuing it for purposes of determining whether they're an investment company, will go outside and seek an appraisal, and we'll find that the $3 asset was really has a current value of $7 million, and there may be no Investment Company Act problem at all. Let me go on. I want to make this point that in 3A3, you'll note it also talks about owning or holding securities. That's a clear suggestion that for purposes of Section 3A3, it's sufficient even if your portfolio is inactive. That is, you can have an inactive portfolio and still be caught by Section 3A3. In effect, 3A3 deals with companies that are not primarily engaged in the business of investing in securities, but companies partially or primarily in a non-investment company business, but which have such a substantial portion of their assets invested in investment securities in expectation of profit, so as to be a company, an investment company for purposes of regulation, unless some exception is available, including demonstration of primary engagement in a non-investment company business. I've pointed out already, but I want to say it again, values, always current values. And
That's, Sid, with respect to cash and cash items.
Right.
That is always, it sounds simple, but that in itself can become very complicated.
Yes.
Cash is cash, but when you get into the word cash items, it becomes very, very difficult sometimes to determine whether cash items are really securities or whether they're cash. For example, a CD may well be a cash item for some purposes and an investment security for other purposes. Are you going to get into that?
Yes, I'm going to get into that right now. The question of whether something is a cash item or an investment security is, as Sid Mendelson suggested, perhaps one of the most common debates that we have with outside counsel. We take this position that CDs are generally not cash items. We also, by the way, say that commercial paper is not a cash item. CDs are generally not cash items and rather are investment securities, with one possible exception. If they're held in aid of an operating business requiring large liquid assets, we might in a particular case accept them as cash items. Now, there's a famous case, a Fifth Avenue case, which holds or seems to hold differently, but frankly we disagree with that district court case, and the point, while the case was appealed, that point was not appealed, and in fact the finding was not even as to whether a CD is a cash item or an investment security wasn't even necessary, considering what the court held. Let me just say this, that if you have any questions now about the definition in 3A3, we'd be happy to try to deal with them, or in 3A1. Otherwise, I would intend to go on and to give you, in the few minutes remaining on this tape, a few specific applications of the 3A1 and 3A3 definitions, sort of examples.
With regard to the definition of owning or holding securities for purposes of 3A3, are there situations where a company holds securities in trust, or it's other than the beneficial owner, where it's included in for the purposes of the definition?
Well,
I'm not sure I understand the question. Perhaps you can restate it.
Describe a situation where it might have an inactive portfolio.
Yes.
Can there be a situation, say, where it's not actually the beneficial owner of, meaning the people who are the shareholders of the investment company are not the beneficial owners, somehow it acquires securities which it holds for benefit of a third company or another third party.
I don't think we've ever had a situation like that. It's hard to visualize your question. If the company is holding, is owning, is controlling those securities with the intent of making a profit, and it is not a trust company such as holding securities for the benefit of others, but if it has a beneficial interest in those securities, then I would say we would probably include that in the company's securities holdings. I would like to discuss something when we come back on the next tape. Okay. That's right.